There are two huge legal cases happening right now in British Columbia between the First Nations and the government that if you're a homeowner or a potential homeowner, you need to pay attention to. In August 2025, a big decision was made in the Cowichan Tribes v. Canada legal court case. This decision was made in the BC Supreme Court. The judgment recognized Aboriginal title over a portion of land in Richmond, Lulu Island, and some parts of the Fraser River. And at the same time, there's another major court case going on in Kamloops. Various nations within the Sawepmuk peoples filed claim in 2015, and they are seeking Aboriginal title over roughly 1.25 million hectares of land, which includes basically most of Kamloops and Sun Peaks. In both cases, the conflict is between long-standing Indigenous title and the modern fee simple ownership system. And now homeowners, governments, and lenders are facing pretty significant uncertainty. So let's talk about what happened, a little bit about why it's happening, and what some possible repercussions might be for homeowners. On the Richmond side, the court ruled that the long-standing fee simple titles unjustly infringed on long-standing Aboriginal land titles. Now, fee simple title is how most private land is held in Canada. Think of it like private ownership, basically. So if you own a home on a piece of land, you probably have fee simple title. The court also clarified that the province's land title system, which is governed by the Land Title Act, does not protect registered fee simple title from being challenged on the basis of Aboriginal title. The court actually declared that many of the fee simple titles owned in the Richmond area, both privately and by the Crown, are non-valid. Now, of course, the ruling is being appealed, and there is currently an 18-month stay in place to basically allow people to figure out what is going to happen. And while the Cowichan tribe did not specifically say that they're trying to go after privately owned land, this decision opens the door for future claims in a pretty significant way. Now on to Kamloops. The Ste Kamloopsem people in 2015 filed a claim over what amounts to a very large portion of land in the Kamloops area. This includes private lands, crown lands, some railways, mineral rights, and some other things as well. Now, of course, the province is opposing these claims on the basis that private property rights must be upheld. And while no decision has been made in the Kamloops case like it has in the Richmond case, the Richmond case, again, is opening up that door. And the concern is that this Kamloops case could be the next major test of private land ownership. Let's talk a little bit about why this is happening in the first place. In the late 1800s and the early 1900s, much of the land titles that we have today were granted by the Crown, but they were granted without treaties in place. And for reference, approximately 95% of BC is on unceded territory, meaning it is in a location where there's no treaty or otherwise agreement of some sort with the Indigenous people that lived there. Now, the Cowichan case specifically emphasized that the Cowichan people used to use that land for fishing, harvesting, and permanent settlement. And they had exclusive control over the area prior to European sovereignty, meaning that legally these lands met the test for Aboriginal title. Now, there's an important note here. The land title system in BC is based on what's called indefeasible title, meaning that once title is registered, it's secure and it's protected by the Land Title Act. But the court found that this system cannot override Aboriginal land title, because Aboriginal land title is constitutionally protected. Now, as with anything to do with reconciliation, this is a very, very complex issue. And unfortunately, it was made worse by our governments allowing ambiguity to build, because many Indigenous title claims have been in the process for years, and they've been left unresolved. So local governments, corporations, and other private land owners and homeowners like you and me have unknowingly been carrying this risk. And the risk is that one day these Aboriginal titles might one day challenge our otherwise solid ownership of these lands. So essentially, this mess is of our government's own making, of course, because there's decades of unresolved cases, treaty abandonments, and no clear path to reconcile private ownership versus Indigenous rights. So what are some of the potential repercussions that might come from this? Well, first and foremost, homeowners in the affected areas are going to face pretty serious problems, particularly when it comes to refinancing, selling, or otherwise leveraging their properties. Because lenders see uncertainty as risk, and surprise, surprise, they don't like risk very much. So this basically means that they're stuck. They can't sell the homes because who's going to buy something when they don't have a title that you can rely on? And they can't mortgage it because the banks don't want the risk. So they're basically stuck with a completely illiquid asset. And there's a danger here for the whole idea of Indigenous reconciliation that needs to be considered very, very carefully. Because homeowners have relied on the Land Title Act, whether knowingly or unknowingly, as the backbone to protect their investment, to protect what is, in most people's cases, their largest asset that they own. So if reconciliation happens by simply taking that title away from those people and effectively demolishing the value of their assets, public support for the whole idea of reconciliation will die off very, very quickly. And the challenge is, the Kamloops case shows that Richmond isn't just an isolated little area. In fact, the provincial government admits that there are other cases going on. And even worse than that, they admit that the homeowners that might be affected might not have even been notified. So here's the bottom line. Private homeowners effectively are left holding the bag for the mess that our government created. For years, they've known about unresolved title claims across BC, and they knew that our land title system wasn't designed to account for it. And still, they pushed ahead with development, they sold land, they collected property taxes, and they told people that their property was secure. Now that the courts are starting to recognize Indigenous title claims, the government's negligence basically has come to a head. And unfortunately not on the bureaucrats, but, for the private homeowners who bought and sold and owned their homes in good faith. And instead of stepping in with either protections or compensation or some kind of solution, they've basically just stayed silent. Now this is important. Reconciliation must move forward, but doing it by screwing over private homeowners, that's the wrong approach. We need a solution that honors Indigenous rights and also protects homeowners who relied on this system that the government built. So if you own a property in one of the affected areas, call a lawyer, one that is familiar with dealing with Indigenous title claims. Otherwise, drop your thoughts in the comments below. I'm Angelo with the Atlas Group. I'll see you in the next one.